Or why not? And remember, in order to get a warrant, you need probable cause. Now, what's probable cause? Well, the legal system has pretty much defined probable cause as any trustworthy information which can establish the likelihood of the commission of a crime. So there has to be trustworthy information that establishes a crime is being committed. Okay? So what is a search and seizure? So the Fourth Amendment again says, the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure. So what is search and seizure? And there's a number of cases which have tried to define what we mean by these terms. So first, we're going to look about this idea of search and seizure. And we're going to look at the case, United States Supreme Court case of Katz versus the United States. And Katz versus the United States was decided in 1967. Now let me give you the facts of Katz and think about how you feel about this case. So what happened is the FBI attached a listening device to a public telephone. Because they expected that there was illegal betting going on this public telephone. So, sure enough, Katz gets into the telephone booth and he starts placing wagers. And Katz then is convicted, based upon this information, of 8 counts of transmitting betting information by telephone from Los Angeles to Miami and at Boston. And at trial, the major evidence against him was that the government was permitted to introduce the evidence of the defendant's end of the conversation, which they had recorded through this listening device. And it was a listening device they had attached to the outside of the public telephone. So the issue is whether or not a public telephone booth is constitutionally protected. In other words, is it an area to which there is a right of privacy to the users? And secondly, whether you need physical penetration of a constitutionally protected area before a search and seizure can be said to be a violation of the Fourth Amendment. So in other words, it's kind of a two-step question. First, is a public telephone booth constitutionally protected as a private area? And that's controversial enough. But then secondly, even if it is constitutionally protected as a private area, do you then need penetration for there to be a violation of search and seizure law of the Fourth Amendment? In other words, if you put the listening device outside the telephone booth, there is no physical penetration. So how does the Supreme Court decide this? How would you decide this? Does someone in a public telephone booth have a right to privacy? Is it a right that's constitutionally protected? And if it is, do you need physical penetration of the telephone booth in order to have a violation of search and seizure law? Well, let's look at how the Supreme Court decides this case. And it was a 7-1 decision in Katz. So in other words, they were pretty much overwhelmingly in agreement with how to decide this case. And here's what they said. The Fourth Amendment protects people, not places. So what a person knowingly exposes to the public, even in their own home, is not protected by the Fourth Amendment. However, what a person seeks to preserve as private, even in a public area that is accessible to everyone, may be considered protected and constitutionally protected. And the Fourth Amendment does not turn on the presence of physical intrusion. You do not need physical intrusion. So let's think about that. Is that good law? Is it not good law? Well, in this case, as a result of the decision by the United States Supreme Court, this recorded evidence was thrown out against Katz, and they couldn't convict them. But to what extent does this go? So, Katz was in this glass telephone booth. And he's talking on the telephone, and they have a listening device outside the telephone booth, and they're saying this is not admissible. Well, what would happen if the FBI agents had hired a lip reader? And the lip reader, using their binoculars, reads his lips. And he's saying, place 5,000 on Seabiscuit. Place 4,000 on Black Beauty. Is that admissible? Well, according to the Supreme Court, that would be admissible. Because what Katz was trying to get privacy from was the uninvited ear. So he had a reasonable expectation of privacy when he closed that phone booth door, that people would not be able to hear him. But on the other hand, according to the court, it's not like he became invisible. So if he's in a glass booth, he cannot have a reasonable expectation that he can't be seen. He doesn't have a reasonable expectation that people can't read his lips. So there, in that case, those kinds of things would not be constitutionally prohibited and could be admitted at trial. All right. So there's been a lot of cases that kind of try and figure out, how far does this go? And another case that's kind of interesting, a more contemporary case, is Kylo versus the United States. Kylo versus the United States. And in the Kylo case, we have a situation where the United States government uses a thermal imaging device. And they go through this high crime area that's known for drug dealing, and they point the thermal imaging device at different houses to detect whether or not people are growing marijuana. And pursuant to that, they find that a couple of houses had very, very high energy emissions, which means that they're probably growing marijuana. So as a result of that, they're able to get a warrant. They go into the house, and sure enough, these people were growing marijuana. So it was Danny Lee Kylo growing marijuana at his home in Oregon. He's then charged with growing marijuana and was convicted. He then appeals on the basis that thermal imaging devices constituted an illegal search under the Fourth Amendment. An illegal search. So the question is that a illegal search or not? So the government says it's not illegal. Why? Because we didn't go inside of his house. This was heat that was emanating through the roof of his house, and we were then collecting it in public. We never went on his land. We were across the street. So it's a pretty controversial case. And it's a very closely contested case. 5-4. And in this case, the Supreme Court ruled in favor of the criminal defendant, Kylo. The ruling was that using this device constituted an illegal search and seizure because they did not have a warrant to use the thermal imaging device. They indicated, the majority, that a person has a right to privacy in their home, and that the government, because of this, could not conduct this type of search with any kind of technology that can detect things emanating from within the home. So one of the things that Kylo does is it also talks about the role of modern technology in search and seizure. And what they say is, if something is common technology that the whole public has access to it, all right, you do not have a right to think that it can't be used against you. But when it's something like thermal imaging that most people don't have, then you have a right to believe it's not going to be used against you. So what the heck does that mean? So again, use the example of if Kylo was in his house, or in his greenhouse in this case, and they used binoculars or a telescope, and they could observe him growing his plants and picking them and smoking some of them, okay, that would not be considered an illegal search and seizure because it's common technology, binoculars. So these are the way we've decided some of these cases.